All right, everyone, welcome to our group's presentation on Section 2.5 on protecting privacy in the technology, markets, rights, and law. I'm Kyle, and this is our presentation. So first off, a little bit about protecting the privacy of people. There's different ways that can be done. First off, individual programmers post privacy protecting software online for free for anyone to get. Entrepreneurs build companies to provide privacy protection. Many businesses improve their policies and services for their employees and customers to have the added privacy. And then there's also many nonprofit organizations out there that provide the public with information that better suits them and gives them the information they need on the current privacy laws and issues with privacy out there right now. As for the technology on the market, technology can actually help solve a lot of the problems with privacy out there. Cookies that websites use to track you and what you do on their sites can be disabled by the users on the browser. Ads that are targeting customers either through email or on the sites themselves can be disabled and blocked with plugins such as AdBlock. There's also free spyware software that's available for everyone to use. This is so if your computer doesn't get infected with any type of software that could possibly be used to track your movements online or offline. There's also products that prevent forwarding, copying, or printing of emails. This is used in some client type of fields such as lawyers and hospitals, so that way they cannot print out the emails and give them to their friends or colleagues and everything, and it keeps everything very secure and safe for the people who need that. There's also services that allow you to erase all text and emails from your phones, either directly or remotely. This is so if your phone either gets hacked, you can get all of your personal information off it, or if your phone gets stolen or you lose it, you don't have to worry about someone having your phone, having your contacts, all of your text messages, emails. You can just get rid of it immediately. However, they don't solve all the problems. That's where encryption comes in. Encryption transforms data into a form that is meaningless to anyone who intercepts it. So there's software on the user's computer that basically uses a mathematical algorithm to substitute characters and numbers in for the real words. Then it gets sent over the internet to the server, who then uses that same algorithm to decrypt it and get the original message back. There's also digital signatures, which allow users to actually sign their name online so that they don't have to print out a paper and then either rescan it into the computer or send it via mail. They can just do it online. A lot of medical professionals actually use this as an easy way to get patient information and sign for prescriptions. And then there's also digital cash. This is so businesses can get the money they need, and you can get the products that you want without having to give them your credit card information or an actual check. However, with enough time and a powerful enough computer, you can easily crack any type of encryption that you can get. So now I'm going to go over a couple of the policies the US has about encryption. Up until the 1970s, encryption was handled exclusively by the government. In fact, by our favorite branch of the government, the NSA. In the 1990s, the government began restricting people from using secure encryption tactics. And in fact, the FBI enforced a bill requiring encryption products to come with a backdoor they could access. This is actually a very big problem because it meant that anything that was sent over the internet could potentially be monitored by the government. They argued that they would need a court order, but it pretty much undermined the entire idea of encrypting and making data secure, which is why in 2000 the government removed all restrictions and stated that source code is actually speech, just like any other type of language, and was protected under the First Amendment.
Hello, I'm Robert Urtelis here, and we're going to be talking about policies for protecting personal data. Businesses, organizations, and government agencies have a lot of personal information on us. This includes things such as your home address, your social security number, credit cards, and this is the type of stuff you don't want just anyone having. So these companies and agencies must be responsible when possessing this type of information, and they must anticipate risks and prepare for them. If you're walking around with an expensive laptop that has important client information on it, you have to be prepared that someone might want to steal that. And your employer should really train their employees about this type of thing and make sure they know. A well-designed database contains several factors to keep it secure. These are things such as every person must have a unique ID and password. There should be no reason for any two people to have the same ID when accessing such a type of database, because then you can't really figure out who's doing what. And you should also restrict writes and deletes. If someone has no business writing or deleting a certain table, then they shouldn't have the privilege to do that. Also, you should restrict read privileges too. Databases containing consumer information, web activity records, and cell phone location data is very valuable to companies. This is the type of information they use to target you for ads and to try to make you buy their products. And they also want to keep their customers happy, so they don't want that information leaked. Some websites actually pay thousands to millions of dollars to private privacy auditors who actually go in and try to steal information from your website. The chief privacy officer is the person responsible for a company's privacy and making sure that it's all satisfactory. Privacy, it's a really big, important thing for businesses, you know. If you find out that Amazon is giving away your home address and information like that, you're not going to want to shop there anymore. Microsoft and IBM actually stopped posting ads from companies who had an unclear privacy policy on them. And Disney and InfoSeek Corporation also stopped posting ads from companies that had no privacy policy. Interesting. So do we have a legal right to privacy? Before the 1890s, there was no legal right. Until right about then, two guys by the name of Samuel Warren and Louis Brandeis wrote an article called The Right of Privacy. This article discussed that privacy is a distinct right, separate from other rights, and a little more important. And Chris will tell you more about those guys.
All right, I'm Christopher Buss, and this is my section. So Warren and Brandeis talked about how everybody had a right to their own personal information, and basically that you can't say anything really about anyone in any sort of publication. And the problem with this is that notion of privacy is way too broad, and it conflicts with freedom of the press, because if you can't say anything about anyone in any sort of mass publication, then that really restricts what you can actually say in the press. Then Thompson basically had the argument that privacy is never actually really violated in itself. It's always through the violation of other rights that someone's personal info is essentially taken against their will. So there's never really a violation in terms of privacy, but usually other rights are violated, and it kind of stems from that. The problem with that is that, and the book doesn't actually give examples, but it says that a lot of critics cite examples where privacy can be violated without actually violating other rights, which then kind of is a problem for Thompson's view, because in Thompson's view that wouldn't be a violation whatsoever. The But the other problem is that the notion of the right to our person is vague and broad. So Thompson also describes that there is this sort of right to ourselves that we have, but she never really explains what that right really is, which is another major criticism. It's important to note, though, that neither of them actually refute the other. Warren and Brandeis concentrate more on the publication of personal info, and Thompson is more about how it's actually obtained. What it comes down to, though, is that they both also agree with consent. So if someone gives away their personal info, then it's not actually a violation because it was with consent. So the book then jumps into actually applying the theories. Publication of personal information is objectionable. So obviously that's what Warren and Benedict, I don't know. That's what they believe. Brandeis, and that's kind of the point of view that the court takes. So a lot of times, the publication of, like, mass publication of personal information is objectionable, and that's usually what it comes down to in court. However, that doesn't exactly say that something like targeted advertising or targeted marketing is bad. So publishing information from a consumer database would be wrong in their eyes because it's mass publication. However, they wouldn't have any problem with actually having targeted marketing, so having just certain people look at information that they may find useful. And a lot of people would still consider that a violation of personal information or privacy, but with their argument, they would not. The other problem would be that their argument would severely restrict social networking sites. So a lot of times when you're on Facebook or Twitter or something, you can share your location, you can share pictures, but a lot of times it's not just of you. In fact, the whole point of a lot of social networking sites is to kind of share experiences. So if you post photos of not just yourself but a lot of friends, or reveal the location of not just yourself but a lot of friends, that'd be considered mass publication of not just your own consent, but you would also be giving information out about your friends, and that would be against Warren and Brandeis also. The book then jumps into transactions. So the problem is, how do we apply philosophical and legal notions of privacy to transactions which automatically involve more than one person? The book gives an example of a transaction that's pretty simple. It's Joe and Maria. Basically, Joe is attempting to buy potatoes from Maria, and Maria is obviously selling potatoes to Joe. But either Joe or Maria may be disreputable, and maybe Joe doesn't want other people to know that he bought potatoes from Maria, or maybe Maria doesn't want other people to know that she sold potatoes to Joe. What it comes down to then is who actually owns that information of the transaction. So Joe could actually, if he didn't want people to know that he bought potatoes from Maria, go buy potatoes somewhere else, or maybe Maria might charge him more to not disclose that information. Or it could go the other way around, where Maria might end up charging Joe less because she does not want him to disclose that information, or she might just not even sell potatoes to him in the first place. What it comes down to, though, is that you really have to ask if there is a convincing reason for either party to have more of a right than the other to control the information about the transaction. And this is true with a lot of cases, especially when you think about signing up for things like social media. Who really has a right to your personal information? And it's almost like borders on blackmailing. Okay, so the book talks about Judge Richard Posner and his kind of view of what or who should own personal data. He says that information has both economic and personal value, and that some information should be in the public domain, while information that has value to society and is expensive to discover, create, or collect should not be.
A basic legal framework. One task of a legal framework is to enforce contracts. and contracts are basically just a mechanism for implementing flexible and diverse economic transactions. The book describes a case about a company called ToySmart. They were a web-based seller of toys who eventually they went out of business. They just weren't making enough money. And being a web-based company, they didn't have any assets, so they just had high amounts of debt. And the creditors that supplied them the money wanted their money back and decided that since WebSmart kept a database, it was a database on customer information like names and addresses, things like that, they wanted to sell that database to raise money to try to recoup some of their losses. But ToySmart had a policy that they didn't release information, so when it got taken to court, the courts decided that that database had to be destroyed and that the information couldn't be released or sold. The second task of a framework is to set defaults. It tries to cover the holes left in contracts, because when contracts are written, none of them are perfect. They forget things, or just there's holes in there that no one thinks about. Like, for example, there's a website with no policy on what to do with collected information. If there was a default for protecting privacy, it would say that that information can only be used for its intended purpose, that it couldn't just be leaked for no reason. Third task is to specify penalties for criminal offenses. Law can specify penalty for violation of policies and breach of contract. For regulation, there's hundreds of privacy laws out there. They pretty much act as guidelines for government agencies to make regulations. Now, regulations do have high costs. They come in two different varieties. There's direct costs and hidden or unexpected costs. Direct costs are dollars out of pocket for business. They're money that the business actually has to spend because of the regulations. And the hidden or unexpected costs are things like loss of service or inconvenience, just things that are there but they don't have a direct dollar amount tied to them. And now regulations may have disadvantages, but they're helpful in protecting privacy. Now there's two different contrasting viewpoints that this goes over. The first one is the free market view. And what the free market view is, it's market-oriented solutions to problems. It's letting the market decide what is a better solution to a problem. It's the freedom of individuals as in customers or businesses, to make voluntary agreements. It emphasizes freedom of contract, so people should be able to freely enter into agreements for a fee or service or any other benefit like that. And people who support the free market view, they prefer to avoid restrictive or detailed legislation. They feel that that can stifle innovation, and they say that the political system is worse at determining what consumers want than the free market system is. So pretty much the government shouldn't be allowed to decide, oh, this is what people want. Throw both products out there and let the market decide what the better solution is.
Hi, I'm Misty Lowry, and I am going to cover the consumer protection view. So the consumer protection view, the emphasis is on people do not realize all the ways that others may use information about them. And people also don't understand the risks of agreeing to disclose their own personal data. The focus of the consumer protection view is that the protection of consumers against abuses and careless handling of information by businesses. It also protects the public from their own lack of knowledge, judgment, and or interest. So consumers are not in a position to negotiate contract terms with businesses. Consumers have two options. Either they accept or reject what a company has to offer. Most of the time, the consumer is not in a position to reject that contract. For example, if a consumer wants a loan for a house or they want a loan for a car, we have to accept whatever terms the lender is currently offering. Another example is if you want a job. We most likely will agree to disclose personal information about ourselves against our true preferences because we need a job and we need to make a living. We as individuals have no real power against large companies such as Google and Apple. We have to use a search engine to surf the internet. And we have to abide by the company's policies that they put forth. So the next section that I'm going to cover is over the privacy regulations in the European Union. In 1995, the EU created a comprehensive data protection directive. That directive covers the processing of personal data, including collection, use, storage, retrieval, transmission, destruction, and other actions. The European Union, their rules are more strict than the US. For example, Google modified its privacy policy in 2012 to allow companies to combine information it collects on members from its various services. The EU agreed that the average users could not understand how Google used their data, and under the new privacy policy, it violated the EU's privacy regulations. Another example was a court in Germany said that some of Facebook's policies in its member agreement, for example, granting Facebook a license to use material members post or store on Facebook, that's illegal there. The German government told Facebook to stop running the face recognition applications on German users because this is a gross violation of German privacy law. So the EU put together legal guidelines for social networking sites. The guidelines say that sites should set default privacy settings at a high level. They tell users to upload a picture of a person only if that person consents. They allow the use of pseudonyms, and it sets limits on the time they can retain data on inactive users. And it requires them to delete accounts that have been inactive for long periods of time. It didn't really state what that long period of time was. So the data directive, the data privacy directive prohibits transfer of personal data to countries outside of the EU that do not have an adequate system of privacy protection. This has caused significant problems with companies that do business both inside and outside the EU. And they might normally process customers and employee data outside of the European Union. The US has privacy laws covering specific areas such as medical information, video rentals, driver's license records, and so on, but it does not have a comprehensive privacy laws covering all personal data. The EU agreed to the Safe Harbor Plan, which allowed companies outside the EU that agree to abide by the set of privacy requirements similar to the principles of the data protection directives to receive personal data from the EU. One of the problems that the US had was after the terrorist attacks in 2001, screening of air travel passengers from Europe to the US raised problems because the US government wanted more information about the passengers, and the EU didn't want to provide that information. So, is the US behind Europe in privacy protection? Many privacy advocates describe the US privacy policy as behind Europe because the US does not have a comprehensive federal legislation regulating personal data collection and use. Others point out that the US and Europe have very different cultures and traditions. The US traditionally puts more emphasis on contracts, consumer pressure, flexibility, and freedom of the market, and penalties for abuse of personal information by enforcement of existing laws, such as those against deceptive and unfair business practices. That's our conclusion, and thank you for listening.